What if the biggest AI workplace danger is not that robots take jobs, but that workers slowly lose the practical ability to defend themselves? Because most workplace rights depend on something people rarely think about: explainability. If you get fired, denied a promotion, disciplined, or treated unfairly, the legal system assumes something very important: that somebody can eventually explain why it happened. Who made the decision? What evidence mattered? What reasoning was used? Was there discrimination, retaliation, bad faith? The entire system depends on the idea that workplace decisions can eventually be traced, questioned, challenged, and explained. But AI quietly complicates all four at the same time. And honestly, I do not think people fully understand how dangerous that could become, because historically, workplace disputes usually left human evidence behind. Emails, notes, witnesses, meetings, contradictions, human explanation that changed over time. Employment law evolved around those traces. Human rights law evolved around those traces. The legal system was built around the assumption that humans leave evidence. But AI systems may increasingly rely on things workers never fully see: risk scores, ranking systems, behavioral analytics, predictive models, optimization logic, training data, and statistical correlations. And that creates a completely different legal environment. Imagine this: a worker complains about discrimination. Months later, they are suddenly selected during restructuring. The manager says the system identified performance concerns. HR says we only used analytics as one factor. The employer says a human made the final decision. The software vendor says we only provided the platform. And the algorithm explains nothing. Now, ask yourself something uncomfortable. Who actually made the decision? And more importantly, who is legally responsible? Because this is where the problem becomes much bigger than technology. Rights do not enforce themselves. Workers usually need evidence. And in many employment and human rights disputes, workers often rely on something called balance of probabilities. In simple terms, is it more likely than not that unfairness affected what happened? And historically, workers could sometimes build that case through patterns, timing, emails, contradictions, comparisons, or suspicious explanations. But now think about how much harder that becomes if the worker cannot see the model, cannot access the scoring logic, cannot examine the analytics, cannot understand the recommendation system, and cannot fully identify how the outcome was generated. That changes everything. Because rights become fragile once people lose visibility into how workplace decisions are actually being made. And maybe this is the part people are underestimating most. The AI workplace may not look unfair. It may look efficient, objective, optimized, professional, data-driven. That is what makes it psychologically dangerous, because unfairness may increasingly hide behind the appearance of mathematics. Bias may look like analytics. Discrimination may look like scoring. Surveillance may look like productivity optimization. And control may look like efficiency. But there is another legal problem most people never think about: discoverability. Modern workplace disputes depend heavily on discoverable evidence: documents, records, internal reasoning, decision trails. But AI systems create a world when increasingly important workplace outcomes may emerge from opaque systems. Vendor-controlled models, changing algorithms, and probabilistic outputs workers may never fully access. And if workers cannot meaningfully examine the reasoning underneath, how do they realistically challenge unfairness? That is not just a technology problem. That is a procedural fairness problem. And maybe this is where the legal system itself starts struggling, because courts depend heavily on explainability. Judges ask, why was this worker terminated? Why was this applicant rejected? What evidence mattered? Who relied on what information? But what happens when increasingly important workplace outcomes emerge from systems that even organizations struggle to fully interpret themselves? That is the terrifying possibility: a future where workers are judged by systems that nobody can fully cross-examine. And this becomes even more dangerous because AI moves much faster than law. A company can deploy a hiring algorithm, a behavioral analytics tool, a monitoring platform, or an automated productivity system within weeks. But courts move slowly. Regulators move slowly. Appeals move slowly. Legal systems evolve slowly, which means the workplace may change first, and the law may only react after the damage is already happening. And governments are starting to realize this. The European Union's AI Act treats many workplace AI systems as high risk. That includes systems connected to employment, recruitment, worker management, and workplace opportunities. And honestly, that alone tells you something important. If governments are creating entirely new AI frameworks, it means traditional workplace law was not built for this environment. But maybe the most dangerous illusion is this. Companies may still say, don't worry, a human is involved. Fine, but what does that actually mean? Did the human truly challenge the recommendation? Did they investigate the reasoning? Did they understand the model? Or did they mostly trust what the dashboard suggested? Because those are very different things. And this creates what may become one of the defining legal problems of the AI workplace, the human-in-the-loop illusion. On paper, the human still makes the decision, but in reality, the system may already shape the outcome before the human meaningfully enters the process. And legally, that matters enormously, because a human signature at the end of a process does not automatically make the process meaningfully human. And honestly, this may be the real warning of the AI workplace era. Not simply that AI becomes more powerful, but that workplace rights may slowly become harder to meaningfully enforce in practice. Not because rights disappear, but because the systems affecting workers become harder to understand, harder to challenge, harder to investigate, and harder to legally penetrate. And maybe that becomes one of the biggest employment law questions of the AI era. Can legal systems built for human workplaces still protect workers inside algorithmic ones? Because if the answer is no, then the future of worker rights may depend not only on creating new laws, but on rebuilding the entire idea of accountability itself. And this is exactly why this series is exploring something much bigger than AI tools. Because AI may not only change jobs, it may change worker rights, evidence, fairness, surveillance, management, accountability, and the balance of power inside the modern workplace. And in the next videos, we are going much deeper.